My name is Todd Gleason. I am your moderator for the day. I'm with University of Illinois Extension. This is the FarmDoc Daily Live Coronavirus and Ag webinar series. Ag law issues in the COVID-19 pandemic. Harrison Pittman is here from Arkansas, Jonathan Coppess and Bryan, Endres, both from the University of Illinois. I do want to remind you very quickly that today's presentation and the question and answer session is for educational purposes only in this way. Legal issues are very factual and situational specific. And what's offered today are general comments and examples only to illustrate the legal rules. The responses that you hear are intended to and should not be construed as legal advice or the formation of an attorney-client relationship. So they're not intended to be that sort of thing. No viewer, user, or browser of this webinar should act or refrain from acting on the basis of information presented here without first seeking legal advice from counsel and the relevant jurisdiction. So with that disclaimer, we'll get started today. Bryan Endres is with us. Hey, good morning to you, Bryan. Thanks for being with us. Why don't you tell us just a little bit about yourself, and then you can start your presentation, please.
Thank you very much, Todd. Yes, my name is Bryan Endres. I'm a professor of food and agricultural law at the University of Illinois, and also a graduate from University of Illinois College of Law. I first like to thank my colleagues, Harrison and Jonathan, for joining me today here. And Todd, of course, thank you for hosting not only this discussion, but all of the FarmDoc Daily Live webinars we've been doing in this series. You know, I'm sure as everyone knows who's on this webinar, the COVID-19 pandemic really has sent shockwaves through the agricultural production system. And the previous FarmDoc webinars have explored a lot of the economic and policy implications. So today we just hope to provide a little bit of insight into a few of the legal issues raised by COVID-19. We'll start today's discussion with the fundamental aspect of any business relationship, the contract. And this, whether it's executed with a handshake or, I suppose in today's environment, an elbow bump, or a 100-page document full of appendices. The basic principle is that a contract binds the two parties to a deal. Yet the news right now is full of these incredible stories regarding canceled shipments, refusal to accept scheduled deliveries, failure to pay, etc. And this is really impacting both the crop and livestock and poultry supply chains. So what I'd like to do today, rather than give you a bunch of legal terms on a slide, is work through a flow chart to help identify how to resolve some of these issues of a broken contract or a potentially broken contract. And although this might sound strange coming from a lawyer, the first step is not to go to court. It's important to remember that a contract is simply a deal between two or more parties. It was negotiated at some point in the past, and it could be renegotiated now, especially given these unprecedented times. And in situations where there is an expectation or maybe a hope of a longer-term business dealings, the best solution may be to simply sit down, try to renegotiate, keeping in mind that the result of the renegotiation is simply a setting aside of the prior agreement or contract and the formation of a new one to go forward. Yeah, but what happens if there's no resolution in the attempts to renegotiate? And you know, one of the most Googled words now is coronavirus. In the legal community, one of the most searched words now is force majeure. And so what is force majeure? And I suppose more importantly, we'll talk about it. Does your contract contain a force majeure clause? And this is usually some sort of a boilerplate standard form language thrown into the miscellaneous section of a contract. Oftentimes it's simply there because the lawyers put it there, whereas the businesses are busy negotiating the terms of the contract, like price, quantity, dates, location, and just ignore this sort of force majeure language until now. So a force majeure provision usually identifies specific triggering events that excuse performance. And they're most often associated with things known as acts of God that cannot be avoided or prevented, such as tornadoes, floods, earthquakes. Some contracts specifically identify pandemics or epidemics as events that excuse performance. And The contract may specify whether the excused performance is permanent or and therefore terminates the whole contract, or if it's temporary. For example, after the flood subsides, then the performance needs to continue. So if your contract contains some sort of language, a force majeure clause, the question is, how do courts interpret these things? And it's important to remember that each clause is different and must be interpreted in light of the specific contract. But there are some basic principles. The first is that the party that wants to excuse performance or get out of the contract, so to say, has the burden of proving the event truly was beyond their control and that the triggering event, for example, the pandemic, was the sole cause of the failure to perform the contract. And the performance under a force majeure clause generally must be impossible, not just economically impractical. And as you review the cases that have litigated these force majeure clauses, it becomes very clear that mere economic hardship or a change in economic circumstances usually is not sufficient to excuse performance under the force majeure clause in your contract. I'll do a quick example. And fortunately, there's not a lot of examples of this in the agricultural context. I suspect in the future we will have more examples, unfortunately. But a quick example is that a company contracted to have 2,000 hotel rooms at a resort in Hawaii for a conference. And then a few months before the conference, the 9/11 attacks happened. And then, of course, a lot of people stopped traveling. There was economic problems. And the company tried to get out of this, out of the hotel room contract in hosting this conference. And the court rejected this. And it says, and it was very clear, saying that, no, the force majeure clauses do not excuse performance just when something is economically difficult. And then it forced the company to pay for these hotel rooms it had reserved. The other part of a force majeure clause is timing. And this is really important in the fast-moving regulatory landscape we're dealing with now, in that you cannot invoke a force majeure clause if there is some uncertainty about whether the performance will actually be impossible at the time the contract says the performance should happen. And I'll give another quick example about a supplier of a chemical was trying to get out of supplying this chemical to the purchaser. And the reason is that the production of the chemical resulted in significant air pollution that violated the company's Clean Air Act permits. And it knew that upgrading the facility to eliminate the pollution would be very expensive. And so it tried to use the force majeure clause to cancel the contract, because that clause actually included government permits or government regulatory actions as one of those triggering events. But in this case, the court said no, the company could not invoke the force majeure clause because literally for years, the government had not enforced the permit limits on the Clean Air Act, and there was no indication that the government would enforce it in the near future. Therefore, there was no certainty of this sort of impossibility or regulatory action. And the takeaway in this example is that as various levels of government adjust their regulations or prohibitions regarding COVID-19 on a weekly or daily basis in some instances, it is possible that a court would not excuse performance in anticipation of some regulation that may or may not be in effect in the future. In other words, force majeure is not applicable to hypothetical or possible events, but there needs to be some sort of certainty. So a quick summary of force majeure is you need to look at your contract, and if there is a force majeure clause, look at the specific triggering events. Then consider the timing and whether there is some degree of certainty that this condition will exist at the time performance is specified. Keeping in mind that economic considerations alone may not be sufficient. And then also use the force majeure clause, going back to my first point, as part of the renegotiation strategy rather than forcing court action. So what if the force majeure clause is not going to apply, or it's just simply not in the contract? This was a handshake deal or contract based on years of business relationships and trust. There are some what are known as common law or uniform commercial code justifications to excuse performance outside of what we've talked about so far today in force majeure. And those are variously referred to as impossibility or frustration of purpose. But the term that's commonly used now, the umbrella term, is impracticability of performance. And what is going on here is that the court has to determine, again, on a case-by-case basis, whether justice requires altering the general rule that the parties bear the risk that the contract may become more burdensome or less desirable than they anticipated. And again, here, mere market shifts or financial inability do not usually cancel the obligations. It has to be something that is extreme and unreasonably difficult. And then this rule of impracticability may apply. The cases, again, when you look at these over the years, talk about severe shortages of raw materials due to embargoes, crop failures, unforeseen shutdowns of major supply sources that cause not just cost increases, but really significant cost increases, not gradual market shifts. And the other way is that courts will also look at these as if there's some aspect of the performance that would involve a risk of injury to a person that is disproportionate to the whole purpose of the contract in the first place. Now, these clauses or this excuse is usually used in the context of civil disturbances, wars, or things like that, but it certainly could conceivably apply in the case of the spread of a disease. Now, we could talk literally for days about all the nuances of these legal doctrines, but for the purpose of just our quick overview today, and we can talk about it more in the question and answer session, is that the economic circumstances to make something impracticable really have to be extreme and something that is not anticipated by the parties to the contract at the time they form the contract. And when we think about this pandemic and the impact it has, this is something that certainly could rise to the level of impracticability. I'm not saying it would, but it's certainly within the realm of consideration. And I think with this, I'm going to stop and toss it back over to Todd. And again, we can talk, to the extent you have follow-up questions or want to get into more details, we can address all of this in our question and answer session later on, but I at least wanted to give you an introduction to get you thinking about some of these ideas. So thank you, and Todd, I'll turn it over to you.
Thank you very much, Brian. Very, very interesting. If you've got questions, and I bet you do, you can go ahead and write them down or type them out, I suppose, in that question box. It's either over on the left-hand side of the page. It's a gray box in that GoToWebinar control panel, or maybe down at the bottom of your screen, depending on what size screen you have. And we'll get to them once we get to the end of our presentation this morning. We're also joined by Harrison Pittman today. He's the director of the National Agricultural Law Center at the University of Arkansas. Good morning to you, Harrison. Thanks so much for being with us. Can you tell me a little bit about yourself first? And then I think first couple of slides also tell us a little bit about the National Agricultural Law Center. Good morning to you. Thanks for being with us.
Good morning to you, and thank you for having me with you today. And I hope the audience can get over the accent that they're having to put up with today from down here in the more southern regions of the United States. So just a quick little bit about me. I serve as director of the National Agricultural Law Center. I've been at the center in one life form or another for going close to 2 decades now, from 01 and on forward. I became director in 2007 and have dealt with obviously a lot of different issues in the agricultural sector for many years. The pandemic is something that's produced a whole new world to us. Very quickly, for anyone that is not familiar with the National Agricultural Law Center, our mission is to serve as the nation's leading source for Agricultural and Food Law Research and Information. We are a standalone unit of the University of Arkansas System Division of Agriculture, which is basically all your agricultural research and cooperative extension. I'm located in Fayetteville, but part of the Division of Agriculture within the university system. We do have a lot of relationships around the country, institutionally included, in particular, one of our close partners that we, funding partner in particular, is through the USDA Agricultural Research Service, particularly within that, the National Agricultural Library. We work with stakeholders throughout agriculture. So, you know, that's every type of producer across the country, from row crop, livestock, poultry, forestry, aquaculture, and individuals engaged in direct sales and on out. We work a lot with state and federal policymakers, trade organizations, commodity groups, private attorneys, public sector attorneys as well, and the list goes on. But that gives you an idea. And so we function as a nonpartisan research and information center and cover all manners of laws in the agricultural law sector. You see this slide here. This is not a list of everything we're going to cover, by the way. I just wanted to kind of give a segue from Bryan's remarks on contract law into some of the areas that we've seen directly. And frankly, we've been overwhelmed as a staff in fielding inquiries and trying to assist all those various stakeholders that I just referred to. It's been, frankly, it's been a real challenge, and it's not possible to keep up with everything. There is just a tremendous amount in the ecosystem of law and policy right now as it relates to agriculture. You know, Bryan mentioned the contracts. I think that's extraordinarily important, particularly looking back if you're having issues, but looking forward. Are there contracts that you need to review the terms of? We've gotten quite a few inquiries, and it's as simple as and as monumental as you have a livestock buyer who's communicating to dozens of producers that they're not going to accept delivery, and everybody's beginning to to deal with issues like that, grain buyers and so forth. And at the end of my presentation, I have a slide with a lot of resources and links to it that I think can be helpful to you. There's a lot I could say on the contracts, but I'll just to move forward. Last night, I read an article, and it was about truck drivers and how they're having a harder time filling their loads now that transition's taking place. And a lot of it was reflecting on the supply chains and how broken they're going to be for quite a while to come. They know that services and industry in the United States and parts they needed from Mexico and Canada, for example, and then obviously things just domestically as well. And so this is an area that's going to grow up even more and more, and something we're just unfortunately going to be dealing with for a long time. And I'll come back to some resources shortly. We've had a lot, and FarmDoc has done an excellent job of covering some areas that are really relevant that we're not going to touch on. That's, provisions out of the CARES Act, the Paycheck Protection Program, Economic Injury Disaster Loan Program, and eligibility issues with that. There's just a lot there, and they've done a great job already. And so that's not something that we need to go back through. I think everyone knows that there's a lot of issues in the livestock sector in particular, and we're going to touch on some ways that's manifested. Labor and employment, H-2A contracts, labor. There's some basic problems of how you obtain labor right now, and in interacting with all the various consulates around the world, particularly with Mexico. And just having that supply of labor, and then what the pandemic does in terms of Department of Labor interaction and their enforcement of rules on, for example, housing, which you can read into that, congregation and the need to have social distancing with respect to the employee base. We have webinars on that. I'll put those links up. But we've also dealt with areas from like estate planning, basic end of life, people that, basic questions about living wills, power of attorney, quite a bit in the specialty crops, direct marketing arena. An area that I will spend 2 or 3 or 4 slides on, the Defense Production Act. This is one that I think has it's a significant development by itself. It's mainly focused on meat and poultry, but when you factor in everything, the grain industries and everything else that supplies into that, I think this could have an agricultural sector-wide impact as this crisis continues. And of course, all manner of finance and credit issues and mediation. And some of those I'll just provide some links to here shortly. I'm trying to advance my slide, and it's not advancing. There we go. If you go to our homepage, you'll find this picture on the homepage: Agriculture and COVID-19 Resources and FAQs. I would refer you to that. I have the link at the end of this presentation. But this is in frequently asked question format, and we've tried to, as best we can get to it. It doesn't include everything yet, but as best as we as a staff can get to it, we try to update highlights of questions that we receive, resources, some of which we produce internally, others have been done elsewhere. For example, Jonathan Coppess did a terrific article on USDA funding under the CARES Act. And we link to resources like that as a clearinghouse function that we provide to the public. All right, so I'm going to, obviously, just like contracts, the areas I'm about to touch on, we could spend a full hour on just by themselves. And I'm going to do the best I can just to put it in simple terms, kind of in a bumper sticker form, and then we can just go to question and answer with any and all of it. So an area that has been, we thought that this would be a big deal. Where we were wrong, it was even bigger than we thought. This is something that's playing out across the country right now. These, state meat inspection laws and the interrelationship with the Federal Meat Inspection Act, which is the law that governs USDA Food Safety Inspection Service with respect to meat inspection. This has really been overwhelming. One of the areas that not only was it a bigger concern than we thought it would be, it was actually something that we thought was simple on the front end, and it turned out not to be. And at the end of the slides, I have a link to a 50-state guide to states' meat inspection laws that would be a very helpful resource to you. I'm hitting to the next slide, and it's not going just yet. So, all right, so it kind of moves forward slowly, a little delay there. Sorry about that. So as I mentioned, when you deal with the state meat inspection, all of this starts with the federal law, the Federal Meat Inspection Act, FMIA, and that law delegates to the USDA Food Safety Inspection Service the responsibility for doing the meat inspections for meat products that go into interstate commerce. In other words, between the states. Currently, there are 27 states that operate under FSIS inspection. That means 23 states operate with a state inspection program. And the two are very closely linked, so that when a state inspection program is in place, those standards that are used there are, the basic terminology has to be equivalent to the federal standard. There are some differences. But fundamentally, they're going to be very similar, and that allows for intra-state sales. So that product can only be sold within that state. And then you have another category, which are custom harvest facilities, and those are exempted under the Federal Meat Inspection Act. In a lot of places, this would be places that process deer meat, but they may do some others. And they're far more restricted in the way that that product can flow, and restricting how it can, and prohibiting it from basically entering commerce. And the restrictions are less stringent than the state and or federal standards. Now, that's kind of the bumper sticker overlay, and I'll give you a link that has some literature that is non-lawyer friendly to read and has access to all the information for each state that you would need. in pursuing that. But there's two items of legislation right now that are right as we speak. This is a very active issue on Capitol Hill. One is the Processing, Revival, and Interstate Meat Exemption Act, which is often referred to as the PRIME Act. It's been proposed in previous Congresses, but it's gaining new legs, partly out of the concerns that have been expressed by some in the cattle industry as they look at what they're receiving in terms of losses, frankly, at the farm gate level versus what the Packers' profit is currently. That's one aspect of sort of the origins here of the genesis of this kind of getting a rebirth. And then, of course, the pandemic and everything coming with it, and a lot of these producers are interested in having a more diversified market. What the PRIME Act would do is it would exempt custom slaughter facilities from the FMIA and basically say to the states, you set up the standard, and it just goes under that state law. This is controversial, and frankly, you know, everything in agricultural law is controversial to somebody, but this is controversial even beyond that standard. You know, for folks who are in favor of this, they think that this addresses the longstanding problem of a lack of accessible small-scale meat processing facilities, and they think that if you can remove this restriction, this can help open up the market, and certainly temporarily, and they hope long-term, provide a new avenue into the stream of commerce for producers who want to go through these custom harvest facilities. Now, on the other hand, opponents in general are concerned that change would essentially undermine the uniformity of our food safety system, particularly as it relates to meat. And in addition, I think that there could be concerns about the impact on international trade, specifically, you know, standards where we import meat from other countries and they have to meet standards that are substantially equivalent to ours. And so if you have this lower standard at the various state levels, and they wouldn't be all the same, it could be a patchwork, that could impact that avenue of trade. The other law here, states meat inspection laws, new markets for state inspected meat and poultry act of 2019. This is another one that is sort of starting to get more attention on Capitol Hill. This is Senator Rounds of South Dakota, I believe, is the sponsor. It's Senate 1720. And what this would do, it goes back to that framework of the state inspection facilities, and it creates a legal pathway to convert that from being restricted to intra-state sales to interstate sales of meat and poultry products produced under those state inspection programs. Standing alone, what it would not do is impact those states that don't yet have a state inspection program. And so in terms of the politics and how this plays out between various state agencies and their federal representatives, it's going to be fascinating to watch, and all of this is bound to find a home in the debate over the upcoming next stimulus package. Switching gears, this is the Defense Production Act. When I just real briefly, I wanted to kind of put this in some very 30,000-foot context. You know, I mentioned I've been at the Ag Law Center since the early 2000s, and at that time, you know, to me, agricultural law was mainly a law that was driven by finance and credit issues, secure transactions, bankruptcy, guaranteed loans with Farm Service Agency, commodity programs with FSA, some conservation programs with NRCS, administrative appeals. In other words, to me, agricultural law was mostly a law of when the music stops. And it's ironic that we're back in that situation, but in the early 2000s, you know, we were just a decade or, you know, basically a decade removed from the farm crisis, the end of the farm crisis of the 1980s. And so that dominated so much of the legal activity in this arena. And it's just expanded so much over time in terms of genetically modified crops, changes to the federal crop insurance program. We've obviously had farm bills with different programs and policies and regulations implemented. We just had so many changes, but yet even in that context, had you told me 6 or so weeks ago, 8 weeks ago, that I would spend an inordinate amount of time getting my mind around the Defense Production Act and an executive order dealing with meat and poultry processing facilities, or as we'll talk about possibly beyond, I would have just, I think I would have just dug a hole and climbed in it, because I wouldn't want to know what we were going through to make me do that. So this one was a curveball. The Defense Production Act, just very quickly for some historical context, because I think that helps understand what it means or could mean or doesn't mean today. So we go back to 1950. You have in the White House at that time, we have President Harry Truman. We have exited victoriously from World War II. And in terms of the world, we have the atomic bomb, and we also have a lot of debt, and we're also in a post-war spirit. And so in terms of our overall policies, we had, particularly because of the atomic bomb capability, we were able to step back in some degree from military preparedness. And so we had kind of a step back in that regard. And then just a few short years later, the North Koreans crossed the 38th parallel and triggered what we now refer to as the Korean War. And so President Truman was in a situation that we had to mobilize very quickly. And so he goes back to Congress and he asked for what becomes the Defense Production Act. And these laws were predicated on 2 previous laws that were in the World War II era, but they had, they were allowed to expire. And so that's kind of like a really high level sort of background. And this law, it delegates a potentially tremendous amount of authority from the legislative branch and gives it to the executive branch, the president, who can then delegate various things to various department heads throughout the executive branch. And now, obviously, we're going to be focused on the Secretary of Agriculture. And it has to be renewed every few years simply because it have some check and balance between the 2 branches of government there. But here's some of the things that the Act does. It gives, and this is sort of what it's most famous for, it gives the federal government priority in contracts and orders. In other words, it allows the government to step into the private sector and direct the private sector to say, you make, company A, you make blue widgets, and we now need those blue widgets in the name of national security. And so our contract that we're going to say that you must comply with takes priority over anybody else you've contracted with for those blue widgets. And then it has a ripple effect after that, depending on the situation. This is not a dormant law. It's particularly in the Department of Defense. It's kind of standard fare. It's used a lot, but frankly, it's not new with respect to the Department of Agriculture, but we're in a whole new world now with this pandemic. And so that changes the context around it. The DPA will allow the president under certain statutory provisions, and then there's some regulations that come with it we won't get into, to establish guaranteed loan programs, both for private institutions and private businesses. Think of, just similar to what we know through the Small Business Administration and the Farm Service Agency, the loan programs there that are particularly important in livestock, poultry industries. It broadly gives the president what's called appropriate incentives to develop, maintain, modernize, restore, and expand the productive capacities of domestic sources for materials. And I blocked out some of the language. There's quite a few other areas it covers, but materials is what matters the most in this executive order. And so in the interest of time, I boiled it down to just materials. All right, there we go. So on April the 28th, which seemed like a decade ago at this stage, but was just obviously just a few days ago, President Trump issued an executive order. And that executive order is the underlying thrust of it. It's a focus on the bottleneck that's been the enhanced bottleneck, I'll call it, that's been presented because of COVID-19 in the meat and poultry supply chain. In particular, you have employees who are, they're either worried about being sick or they are sick. And unfortunately, some have contracted COVID and passed away. But because of that constriction or that challenge, it's impacted the workforce. And so we don't, the way I think it's thought of, we don't have a food supply shortage. However, we have this challenge with not being able to process it. And for products like hogs and for commodities like poultry, that is particularly challenging. And so this executive order was issued in response to that general challenge. Now, this is, I know I'm going to go through just some statutory language, which by itself is technical, but I think it'll be relatively painless. But it's important to try to figure out, as everybody gets their mind around what the DPA is and what it could mean for the agricultural sector. This language is particularly important. So, important parts of the executive order. It states that meat and poultry in the food supply chain meet the criteria specified in Section 4511B of the Act. 4511B is the portion of the statute that focuses on priority of contract and priority of orders, which we already alluded to. It states that further in the executive order that the Secretary of Agriculture shall take all appropriate action, pretty broad language there, all appropriate action under that section to ensure that meat and poultry processors continue operations consistent with guidance for their operations jointly issued by the CDC and OSHA. And all of that is obviously focused on worker safety and by extension, public health safety in being able to keep employees safe and these plants running. In addition, and potentially very importantly, the executive order also grants to the secretary the authority to identify, if he chooses to do so, additional specific food supply chain resources that meet the criteria in 4511B. And terms like food supply chain resources are, the definition, I guess, is what we would maybe just attribute, how we personally define it. That's not a statutorily defined term. Now, this is one of the more technical parts with the language. This is just an excerpt of the relevant part of 4511B. And it says that the criteria is that such material, which is a statutory term of art, is a scarce and critical material essential to the national defense. Now, before I go to the next part there, the gateway into all of this world is, does this meet the statutory definition of national defense? And it's an extensive definition. It includes a lot. People could read it and interpret it differently. But as a practical matter, in terms of trajectory, if the president of the United States says it's national defense, then it's national defense until proven otherwise. That's a very practical way of looking at it. So here it's that such material is scarce, critical material essential to the national defense, and two, that the requirements of the national defense for such material cannot otherwise be met without creating a significant dislocation of the normal distribution of such material in the civilian market to such a degree as to create appreciable hardship. I highlighted those terms, and we're not going to go jump into them in any detail. I mentioned the national defense. That's an extraordinarily integral part of this statute, but material is a very broad term as well. And both of those terms include other statutory terms, which themselves are broad, and some of those include yet other definitions for applicability. And so as you work through it, you can see an act that has broadening but unknown potential boundaries as to what the authority actually is under the order as it relates to the authority provided in the statute. Now, importantly, you see that last sentence there on that bottom of that slide. The order applies to meat and poultry in the food supply chain. It also, at another point, says it applies to food supply chain resources, and then subsequently says it applies to food supply chain resources, including meat and poultry. So it's safe to know that it applies to meat and poultry in the meat and poultry food supply chain, but it also evidences that it could go beyond that. Very quick, some other highlights from the Defense Production Act that I think are noteworthy as we look at, a pandemic that we don't yet fully know the full boundaries to, and then matched with a statute that we don't yet fully know the boundaries to. And frankly, not possible to know at this point on either one of those. Under the Act itself, it authorizes the president to prescribe such regulations and issue such orders as the president may determine to be appropriate to carry out the Act. That's a very broad grant of authority. In addition, when the president does that, and of course, when we say president, we're now mainly talking about the Secretary of Agriculture, whom this authority has been delegated to. It exempts application of what's known as the Administrative Procedures Act, which is the federal law that governs notice and comment rulemaking, all those laws that make it into the Federal Register. The statute expressly exempts the application of the Administrative Procedures Act. It does have some other requirements within it, but bottom line, it removes it from the scope of the Administrative Procedures Act. Additionally, and I think this is the final point on the DPA, it states in the part of the statute and that no person, and person is a defined term, shall be held liable for damages or penalties for any act or failure to act resulting directly or indirectly from compliance with a rule, regulation, or order issued under the Act, even if that rule, regulation, or order is later declared to be invalid by what the statute calls any court or any other competent authority. And so that is an area not tested. I think traditionally, the way that would be thought of is in the contract context. And when you're dealing with canceling out previous contracts and making the government the priority contractor. But it says, any damages, any penalties for compliance with, and I think that can help, or it's part of the discussion, I think, going forward about, does this apply to the question of liability protection of meat and poultry facilities, for example, that comply with the guidance or a future rule or regulation or order associated with operating these plants during the pandemic. So we're switching gears now from the DPA. So, starting roughly a month ago, we began to get a lot of questions about, what are the laws impacting or potentially applicable to the depopulation of poultry and hogs. Of course, poultry we were familiar with because, unfortunately, of the previous pathogenic avian flu. And so we had, some quick background there. But as we've already noted, with this bottleneck, that hurts the entire supply chain. And so there are instances of this depopulation occurring. I think it's reasonable to presume that is something that will likely continue. There's I think many of you would know, there's a plant in Minnesota that recently reopened. Its sole function is for depopulation of hogs. It's not to slaughter and process. It's to end their lives and to move to disposal. And important highlights here. To my knowledge, there are no state laws that govern this specific area. I would be very surprised if there is one. I don't know of any. The USDA did recently launch what's called the National Incident Coordination Center. For anyone that's confronting this would be one of the entities that you likely want to learn more about. Under that APHIS program, it's going to, you interact with state veterinarians, other state officials. On the one hand, they want to help find alternative markets when possible, but bear in mind, it's particularly with commodities that are vertically integrated or part of a vertically integrated system, that's not a very easy thing to do. And then more often than not, they will advise and assist with depopulation and disposal methods. Through that, the USDA Natural Resources Conservation Service will, under the EQIP program, provide technical assistance and cost share. And if for any further information on that, feel free to email me, and I'm glad to help in any way I can. And I don't have the slide here, but this also brings in the AVMA, American Veterinary Medical Association, and the standards or guidelines that they have for euthanasia and depopulation. But unfortunately, this is an area we're going to be dealing with more. USDA through the Agricultural Marketing Service does have, they did set aside $3 billion out of the some of the funds that were appropriated by Congress to USDA in the last assistance package. And those are for direct purchases, and in the information from USDA, their intent is to also include, some poultry and livestock products. So unfortunately, this is a reality of where we're at the moment in terms of this depopulation. That's something that there's really nobody that wants to see that. But nevertheless, it's been an important feature, and I wanted to make sure we mentioned that. And even though there's really no laws to point to at the state level, for example, and say, here's state X, Y, or Z, and here's what it says, I think hopefully it still helps to know that it would be very atypical for a state to have a law in that area. So I mentioned these are just my list of honorable mentions, and I'll run through these here in the next 3 to 4 minutes. The link there for COVID-19 resources, that is the FAQ page I mentioned earlier. In a normal course of our business, even before the pandemic really has taken hold and impacted agriculture so heavily, we do at least one webinar a month, and the topics vary. But recently, we have products on the regulatory changes at USDA and throughout the federal government. Any regulatory and guidance changes with respect to COVID as it relates to agriculture. We have another program that you can see the recording on dealing with H2A. It touches a bit on some of the aspects of the Paycheck Protection Program, some real nuances there. There are other resources. I mentioned FarmDoc and Center for Agricultural Law and Taxation at Iowa State University has done a terrific job in that area too. So I would recommend, if you're interested, to go to that page and see what we've done and what we have coming up. Our next program will be on ag mediation. Something that we think will become of heightened focus as farming operations and lenders, have to deal with each other, and that's a direct extension out of the contract discussion that Bryan led us off with. Real quickly, just mention the Perishable Agricultural Commodities Act and the Packers and Stockyards Act. I won't go into detail on those, but I thought it'd be important to at least mention them due to the contract discussion that, there are some areas where the federal government has intervened in some of that relationship. PACA has a statutory trust provision, for example, as does the Packers and Stockyards Act, that's designed to protect the seller. That's an area that if you're dealing with fruits and vegetables, PACA is going to kick in. Livestock, which has a broad definition in the Act. If you encounter those, either visit the link there or shoot me an email, and be more than happy to help any way we can. I mentioned the state meat processing laws. The product that I talked about is linked there. The other areas here, agricultural liens. Every time, going back even to the 07, 08 downturn, I hate the phrase, but it does apply. These are issues that happen when the music stops. And there's a lot of old statutes in state codes around the country, and for ag lenders, for example, that may loan out into different states or in a situation where different laws could apply. We have a 50-state chart of agricultural liens that I think could be pretty helpful. And this is an area that, this is a good place to remind that, like under the Farm Product Security Act, it's important to for the person that's wanting to protect their interests, they need to be detailed and follow the letter of the federal law to a T in that with great specificity in order to make sure they protect their interest. Other areas, we have grain dealer and storage law. So there's all your warehouses and dealers that some states have indemnity programs. Others, the statutes give for example, Department of Agriculture the ability to intervene. But as you go, we're looking at a crop season and a time period where there's going to be a lot of financial strain ongoing. Unfortunately, these are areas that can come up more often. The final area that I'll mention, and again, this is something we can move over into Q&A, or you want to email me about. There's this area of, what I call generally farm foreclosure laws. Sometimes that is, they're specialized foreclosure protections for producers, for farmers that can, when applicable, they can delay foreclosure. Sometimes these laws allow the mortgagor it gives them a vehicle to cure debt, or even in some statutes, it can provide a right to redeem the property after foreclosures occur. The other category would be what I call voluntary or mandatory ag mediation, which in effect can be a form of foreclosure moratorium, because it creates a timeline with mandatory provisions that can slow a process and force the creditor and the producer landowner to try to mediate the debt issue between them. So I feel like I talk nonstop. I tried not to get hung up too much, and I see we have a few minutes left to try to answer some questions here. So I'll hand it back over, and I'll quit blabbing here and see what
right. Hey, thank you so much, Harrison. If you've got questions, and we only have 8 minutes before we get to the top of the hour, and we'll finish up about that time, go ahead and put them in that box. We would like to thank our FarmDoc sponsors. They include TIAA, the Center for Farmland Research here on campus, right in Mumford Hall. You can find that at farmland.illinois.edu, along with Compure Financial, Farm Credit, the Illinois Corn Growers Association, FS Growmark, and of course the Department of Agricultural Consumer and Consumer Economics. Coming up on Tuesday of next week, an important webinar for all of those folks who have signed up and taken PPP to discuss just exactly how those funds, which are a loan, can be used in order to qualify for the forgiveness process. So you want to make sure that you join us at that point as well. Let's get to some of the questions for the day. Here's a good question. Are there any legal consequences, Harrison, for meat processors that fail to adopt the CDC guidelines for safeguarding their employees before reopening? I think that your session told us no.
Well, I think there's certainly, if I understand that question, if they're saying they don't comply with it, then I certainly think there could be consequences from that.
Well, it looked like it gave legal liability on either side. Is that true? It said if you act or you don't act.
Okay, so, let's step back from it. So basically the core issue there would be, and this has been reflected in a lot of the public press too, does the executive order on April 28th, and by the way, I keep saying April 28th because there's actually another executive order that is at play here too, that's from 2012 that we don't need to get into, but it also provides authorities. And some of those are already embedded in Federal Register. So that's just a side note for those who want to take a deeper dive. But the president himself had said that in signing this, that this will provide legal liability protection. That's been talked about by other legal experts, and there's been disagreements between very reasonable, very intelligent people who don't see it quite the same way. Some think that the executive order does not trigger liability protection. Others think that so long as the meat packers are making particularly a good faith effort to comply, that will certainly assist in that liability equation in the event there are lawsuits filed in the future that are employee-based and worker safety-based lawsuits. I think it's going to depend sometimes on the state. A state could have a particular tort claim available that might be unique, but negligence claims, I think, would be clearly a part of the picture. And, the key part of negligence is establishing duty of care. And, I could see where the guidelines, even though they're guidelines, are that duty of care. And then I think that now, and to put into context, that statutory language that I shared is something I don't know the full answer to. I don't know that it's ever, in fact, I know it's never been looked at in this context. So when I read it, I'm when I provided that earlier, it's really to raise the issue of, well, how broad is this? It does say any damages or any penalties for compliance, direct or indirect compliance with any rule, regulation, or order. And so arguably, somebody could say, read that and say, well, my goodness, that's so broad, it just can't apply. Someone else could read it and say, you know what, it says what it says, and Congress delegated this authority expressly in statute and could have picked the words that it wanted, and it picked the ones it wanted. It said any damages, any penalties for any rule, regulation, or order, and then went so far as to say that that liability protection would apply even if it's later declared invalid. So, we may never find out the answer to that, because that was something I think would have to be, to go to court, have to be an issue, be decided. And ultimately, some of these questions could find their way all the way to the United States Supreme Court. And so it's an open-ended question. And, I probably didn't talk about that enough or emphasize that enough, that, I think we're in uncharted waters, and the liability issue is one of them with respect to the Defense Production Act and what authorities could be used. I think that, I hope that answered the question, but I definitely think that the liability issue is one that you're going to find reasonable people who don't come down on the same side with that. They're not going to see it the same way.
Bryan, there are a couple of force majeure questions. One of them on ethanol contracts. Do you think it could be used in that form?
I think that it's more likely to be used, maybe not in the force majeure context. Let me back up and say, force majeure, it's always going to depend on what's actually in the written contract. But I think in the ethanol context, you would be looking more at the issue of common law impracticability or impracticability under the Uniform Commercial Code, in that this shift in the market is so profound that it simply could not be anticipated by the parties to the contract in the beginning. And so the court might determine that, yeah, justice really does require just setting aside this contract. I think that's more the situation. There is one example of a purchaser of eggs, and this is one of the few agricultural examples that are out there, where they were buying cage-free eggs, and then there was an unexpected drop in the demand for cage-free eggs, and the court said, yeah, that just sort of happens. You have market fluctuations, and that's no excuse to call this contract impracticable. But then the court said, but if the situation was avian flu or something like that, well, then okay, that's something that the parties to the contract couldn't anticipate, and maybe it would qualify as being impracticable. And so oftentimes what lawyers are doing are they're looking for past cases and examples to sort of signal where a court might go. And in this instance, in the ethanol context, who would be thinking about, a global pandemic and the impact on oil or ethanol consumption or ethanol demand? And so maybe that would be enough.
I think that probably answers the other question we had on force majeure as it relates to hogs not being able to go to market, or any animal not going to be able to go to market because of this event at this point. Is that right?
Yeah, to me, that's a little bit different situation. Is that the facilities being closed, oftentimes by the order of a public health facility, and therefore, and in those situations, it would more clearly be the result of some sort of government regulation or government action that you couldn't anticipate. But if it's the facility closing on its own volition, then it's just so fact specific, Todd. It's hard to give a definite answer. But I guess the way I come down personally right now is that these really are unprecedented times, and the doctrine of impracticability is probably going to apply in a lot of situations.
Harrison, does the executive order give Secretary Perdue the ability to incentivize workers to go on the line? Meaning, can he pay them more?
I have not thought about that before. I don't know
It
for
only
sure.
it says material, so I didn't know.
Yeah, it
whether
would be
that
very unorthodox. Of course,
seems
it's all
outside.
unorthodox.
Yeah.
Sure. My initial reaction to that would be probably not, but I would just encourage. I would encourage anyone who's wanting to look at the Defense Production Act in more detail and to actually listen to more than just me, listen to other people, because I think different people can read this so broadly or more narrowly. So my initial reaction would be no, but I'd be interested in hearing what other people have to say. I just don't, offhand, I don't see the avenue for that. There's that appropriate incentives language, and I don't think this would come within that. There's a prohibition on wage and price controls. You'd have to get around that. And there's a prohibition on like in the priorities and allocations that exempts out employment contracts. So that I just feel like the answer would be no, or probably no. So that I wish I could say absolutely one way, but that's my initial thinking.
Bryan or Jonathan, any comment on that one?
I'm glad you asked Harrison that question.
You're so welcome. I think that'll wrap up our time together. Harrison, thank you so much for being with us. We do appreciate that. Bryan Endres and Jonathan Coppess as well. Harrison Pittman, of course, is with University of Arkansas, and Jonathan and Bryan on hand from the University of Illinois. Jim Bolts has been behind the scenes today, making sure everything works well. He's the technical director. Thanks to him, and thanks to you as well for being with us. Do fill out the survey as you exit, and remember, you can always find these up on our website as a YouTube video to watch again, and the PowerPoints are there as well. You can do that at farmdocdaily.illinois.edu. You have a good afternoon. I'm Illinois Extension's Todd Gleason.
Thank you.